When a company dissolves, what happens to its contracts? This question is crucial for business owners, creditors, and anyone involved with a dissolving company. Understanding the implications can protect your rights and help you navigate potential legal challenges. Typically, contracts with a dissolved company remain legally valid. This means that obligations continue even after the company ceases operations. However, there are exceptions and nuances to consider. Let's start with lease agreements. These do not automatically end when a company dissolves. In fact, the company may still be liable for rent payments or face penalties for early termination. Some leases may have specific clauses addressing business closure, but without such provisions, the obligations persist. This can lead to significant financial strain for the dissolving company. Intellectual property contracts present another layer of complexity. If a company holds copyrights, patents, or trademarks under licensing agreements, the dissolution process can affect these arrangements. When IP assets are sold during liquidation, the new owners may need to honor existing licenses. Failure to address these terms can result in disputes and legal complications. During the liquidation process, appointed liquidators have the authority to negotiate, terminate, or fulfill existing contracts. Their primary duty is to settle debts and distribute assets to creditors. This means that not all contracts will be honored, especially those that do not bring value to the estate. Creditors often take priority over other claimants in this scenario. It's important to note that the ability to sue a dissolved company is subject to state-specific time limits. Many states enforce a limited time frame, often around 3 years, during which creditors or other parties can file lawsuits against dissolved companies. Once this period expires, claims are typically barred. Some states also require companies to publish formal announcements of their dissolution, which may include deadlines for filing claims. In conclusion, the dissolution of a company does not automatically void its contracts. Lease agreements, intellectual property contracts, and other obligations may continue to be binding. The liquidation process prioritizes creditors, and state laws dictate the time frame for potential lawsuits. Given these complexities, it's crucial to seek legal advice if you're dealing with contracts involving a dissolved company. Understanding your rights and options can help you protect your interests in these challenging situations.